Good morning, everyone. Welcome. My name is Andy Bobreck. I am a labor and employment attorney with Bond, Schoeneck King here in New York. We have many clients, many friends of the firm on the line. Welcome to you all. And on behalf of the 250 attorneys, including the 70 management side, labor, employment, and employee benefits attorneys here at Bond, we extend our hearty welcome and thanks for joining us today. It's remarkable how dynamic the area of human resources and employment law has become of late. Of course, it was always a dynamic field, ever-changing, but fair to say the changes that we've seen and are seeing of late are happening at really an unprecedented pace and on an unprecedented scale. I wish I could tell you otherwise, but our sense is that there will be more to come in this area. Today we'll be discussing major changes to New York human rights law and some of the related statutes. Legislation was just signed, in fact, by Governor Cuomo just a matter of days ago. And as we'll discuss, this new legislation is really somewhat of an outgrowth of legislation that was passed last year, focused primarily on sexual harassment in the workplace. We have two outstanding panelists with us today, both fellow labor and employment attorneys here at Bond. We have Teresa Rosnack from Rochester and Howard Miller from our Garden City office, and good morning to you both. So just a couple housekeeping items before we get started here. We put this webinar together in short order. Of course, we want to be responsive. That's one of the great things about this format is we can get this content out to you quick. Unfortunately, we didn't have, because of that timing, the opportunity to submit this for credit through HCRI or SHRM. We are recording the presentation. We will make that recording available to attendees and others on our website, as well as the slides. We were thrilled, absolutely thrilled with the response to this webinar. We have close to 1,000 registrants. We, of course, want to take as many questions as you can submit. What I would ask you to do is please feel free to submit those questions during the course of the webinar. We will be reviewing that. We expect we'll have some time to answer questions that you submit at the end. I don't expect that we'll be able to answer all of them, but we'll do our absolute best. And what we will do is our best to follow up with you afterwards, too, to address your inquiries and questions. So with that, why don't we get started here? So I was talking to, I think, a group not too long ago and mentioned that the new legislation, which was recently passed, and one of the people I was talking with remarked and said, oh, yeah, I remember there was legislation that was passed last year. I had to explain, well, yes, there was some very sweeping legislation that was passed last year, but actually this is new sweeping legislation. So just to recap last year, the legislation was largely focused on sexual harassment and made several amendments to the human rights law in other areas. Of course, most on this call will be familiar with the mandatory policy and training that is now required under state law in the area of sexual harassment. The legislation also created new prohibitions on confidentiality agreements when dealing with sexual harassment claims, and limited the ability of employers to use those types of agreements, as well as arbitration agreements, mandating employees to arbitrate disputes relating to sexual harassment, a prohibition created on that as well. The laws also enhanced protections for non-employees in the workplace and imposed different requirements as well. The key here, I think, to remember is that this was all really focused on sexual harassment. The new legislation, however, is much broader than that and extends many of the same issues that were covered in the initial legislation focused on sexual harassment now to all forms of harassment and discrimination. Beyond that, and we'll talk about these with our panelists in detail today, the new law does a number of notable things relative to workplace harassment and discrimination. Perhaps first and foremost, it will ease the burden of an individual to establish a claim of unlawful harassment. The defenses that employers have had to date when addressing a claim of harassment in the workplace will be limited and restricted. The protections that were initially extended for certain non-employees in the workplace have been expanded. And of course, the penalties and remedies that can be levied against an employer facing liability have been increased. Additionally, both the prohibition on confidentiality agreements and arbitration agreements has been broadened, as we'll discuss in more detail today. And also the notable training and policy requirements that were enacted last year, and I know that many of you are dealing with now and implementing as we speak, have also been changed. And we'll cover these issues today. So with that, I would like to turn it over to my colleague, Howard Miller, who will talk about some of these issues.
Thank you. Before we get into Mr. Weinstein, just to follow up on what our legislature has been up to, these changes are coming so fast and furious and so pro-employee. Wouldn't be surprised me if in the next few days we see a bill requiring paid time off to wait online for a Popeye's chicken sandwich. And last night I happened to be at the Billy Joel concert and at Madison Square Garden, and one of the many highlights of that concert is when he plays New York State of Mind. And so the image is that there's screens all around the garden, and they show the Manhattan skyline at night. The stage lights alternate between orange and blue. It looks beautiful, and he's certainly in his prime doing this, and crowd sing along. And I have to confess, I really wasn't feeling the New York State of Mind, knowing what we were going to be talking about today. I was more thinking that New York has just kind of lost its mind. And as we're going to discuss further, we can be somewhat calm about this, even though there are changes. There have been changes in law before. We've navigated them. We'll navigate all of this. At the end of the program, we'll talk about tips for navigating this and protecting our company. When I think of Mr. Weinstein, and I certainly try not to think of him often, one thing that pops into my mind is that we never want someone like that to be the face of our company. And what I've come to learn, representing all different kind of entities, is that it takes decades to build an institution's reputation. But one bad actor in a viral news story can bring that reputation down. And that's something we want to protect against. So as we see from the news headlines, it seems like every week there's new accusations against someone powerful. And it's good that some of these people are being brought down. Though when I wake up every morning though and see a news alert about one of these stories, it kind of reminds me of the old Tom Petty song, You're Jamming Me, that it just keeps going on and on and on. And unfortunately, you would think that in this day and age, with all the stories and all the people now being held to account, that some of this will stop. But at least in my practice, I'm experiencing and getting calls from clients with still very bizarre behavior, and frankly, they're the type of things that if you saw on a TV show or in a movie, you would say that would never happen in real life. It simply wouldn't happen. That's fake, but it's real. Still getting a lot of calls about employees downloading pornography on their work computers. We had a recent situation for a public school we represent where the IT department doing routine maintenance discovered that one single teacher was accounting for 10% of the entire district's storage on the server. And when they went to look at what he was storing, it was downloaded pornography, including thousands, literally thousands of videos, and some of which were homemade, by the way. And when they confronted him about it, he was kind of matter of fact, and he needed some place to store his collection that took him a long time to cull, just in case a virus got on his home computer. And why not use the company's computer? And again, we tend to frown on that in a public school in particular. Again, we just keep seeing this go on, and one thing that kind of makes me think about is, when did it just become so hard to show up at your job and do your work without just sending naked text to somebody or engaging in this manner of behavior? But nonetheless, this is where we are, and we have to address it going forward. So under the old standard of a hostile environment and harassment, and this is still the same for federal law that it is now, is that the harassment had to be severe and or pervasive. And that's actually a pretty high bar. And in federal court, we've certainly had a lot of success on motions to dismiss and motions for summary judgment, where the facts alleged are pretty bad. And nonetheless, the courts found that they were not severe or pervasive. And again, that's still the law. Under the new law, when it comes to harassment or discrimination, we're looking at whether the conduct subjects an individual to inferior terms, conditions, or privileges of employment. Now, the new law then also sets up another standard, which says that you can't, the fact that an employee can't have comparator evidence or can't come up with comparator evidence isn't dispositive of a case. That seems to me a little contradictory with the prior one. So if you have to show that inferior terms of employment, how do you do that without a comparator? Now, the comparator standard, again, still applies in Title VII claims and ADEA claims. We've used that on motions to dismiss. If anyone is looking for some case citations on that, please just shoot me an email, and I'll be happy to send that. So, in the typical scenario, someone will say, we'll do a pleading that will say, I'm over 40, and my supervisors are treating the younger employees better than me. And we'll move to dismiss saying, well, you haven't pled who, how, and what, so you lose. We're not going to be able to do that, it looks like, on a motion to dismiss one of these claims where there's no comparator. I still think we'll try, because if without the comparator, what is the employee going to rely upon to actually prove discrimination? So again, if the employee says, I didn't get a raise because I was male, because I'm a man, typically they would have to show, well, females got raises and they had the same quality. Your work was up to their same level. So I don't know how they would actually prove it without the comparator. I want to talk a little bit about the federal Faragher Defense. So some of you may recall this. The law, at least for Title VII, would be somebody is a victim of sexual harassment. The company has a policy in place that has a clear line of where they're supposed to file their complaint. The company has done its training. They've done everything they can to do to make people know that you can file a complaint, and the employee does not file a complaint. And we've used this successfully to say, well, the employee can't win that case because they didn't follow the complaint procedure, and that is the so-called Faragher Defense. And it made sense. It was kind of in fairness. So the theory here is that an employer ought not be liable for the actions of a rogue employee who is acting contrary to the employer's interest unless the employer knew about it and had the opportunity to correct it. Now, it's something different if the employer knew about it and did nothing. Then the liability is not because you had this employee acting outside the scope of their employment, but it's actually looking at the conduct of the employer and failing to do something and remedying the situation. Now, the Faragher Defense, there's a nuance to it, and this is this Third Circuit case, and I think it's kind of a big deal. So we know about the Me Too movement. The Me Too movement, in my opinion, has had some great results in that people have now feel more comfortable coming forward, particularly against people of power. They see that you can complain, something can be done. You know, a lot of times it's understandable that someone won't come forward if their harasser has a real position of power within an entity, could be a big rainmaker, so they're afraid to come forward, they're afraid of retaliation. Now, what we have argued in the past with the Faragher Defense is that having, you know, just a unsupported fear of retaliation is not enough to excuse you. But what if it's more concrete? And here's this Third Circuit case, and they go through all of what's happening currently in our culture and in all of the highly publicized cases. They go through some EEOC statistics, and one is particularly important, that 3 out of 4 women who have been harassed in the workplace do not come forward. And they use that as a backdrop against what they were doing here. They found that the company would have to go to trial on the Faragher Defense about the victim not coming forward. And in this case, the victim worked kind of in an isolated part of the company with a supervisor who was harassing her for a long time. She was a single parent. Her child had cancer. She had heard through the grapevine that the supervisor had been subject to complaints of harassment before, and the company really didn't do anything to him. And he kind of made clear that he was in a position of power where nothing would happen to him and she could actually be fired if she were to complain. And so what the court did here is the court noted the fallacy that may be underlying a lot of these cases. There may be times when it's reasonable not to come forward, and in that case it was. So leading on this case, we look at our new standard under the new human rights law, and what is now expressed in statute is that you don't have to necessarily complain. That's not going to be a dispositive fact. But there is still a defense that's out there. So this is called the Respondeat superior defense. And a lot of people forget about this defense, and it's important to raise it. And it is a defense that works in the courts. And again, if anyone looking for some case citations, I'll be happy to give them to you. So what it says is that the employer can't be liable unless they actually knew about the harassing behavior or discriminatory behavior and encouraged and condoned it. We see that a lot with supervisor harassment, where the company didn't know about it, and because of that, the company wins, or the company found out about it and took remedial action and the company wins. So now let's go about, well, how do you square that with this not having to complain? What I think that the employee will need to show, and we'll have to see how this plays out in the case law, that somehow the employer still knew about it. So, for example, you have a partner in a law firm who's harassing an associate. The associate doesn't feel like coming forward, or not doesn't feel like it, but is reasonably afraid to do it. But somebody else witnesses it, and they tell the employer. Well, if the law firm doesn't do anything about it, the law firm would be liable. But if nobody tells, let's say, the firm's management committee or the hierarchy, I think that the firm would have a defense, and that's the same for any kind of institution. Now let's talk about another defense, and this goes to the different standard between a severe and pervasive standard to this new lower standard. So the limited affirmative defense, and when they say affirmative defense, that means the burden of proof will be on the employer. That says petty slights and trivial inconveniences are not actionable. I suppose the legislature was trying to give employers a bone here, that's something that they can hang their hat on. I mean, to me, and this may be a flawed analogy, it kind of reminds me that my daughter's in this mode where she prefaces every statement to me with, no offense, Dad, but, and then what follows makes me say in response, well, what would you have said if you intended to offend me? And looking at this, you know, to the extent that the legislature was trying to help us, I I don't know what it would have looked like if they weren't trying to help us. So what does this standard mean? And again, a lot of these standards are hard to figure out. Just bear with us 1 second, because the slide is not moving forward. Okay. So how do you draw the line with this? So let's look at these 4 bullet points here. So the first 2 are cases that we've cited in court papers and in position statements to New York City Commission on Human Rights, because this standard really comes out of the New York City standard. So the crude anecdote about someone's sex life and references to employees being voluptuous, that was found by a court to be not exceed the standard of trivial inconveniences or petty slights. Same thing, all women are bitches except for my mother. Again, it's nice that he thinks kindly of his mother, but that didn't meet the standard. Now, should an employer still tolerate that? No, of course not. And now the next 2, though, courts found did meet the standard for establishing something above a petty slight, spreading rumors about a female employee and commenting about an employee's ages that made them slow and lazy. So this standard is kind of murky. Still, we're going to rely on the 2 cases cited above to try to argue these cases. But the murky standard, let's go back for 1 second to our Respondeat superior defense. So let's say we had a situation where an employee said the exact things that are in the bottom 2 points bullets. Would we be liable for that? And even though it meets the standard, the answer would be no if we didn't know about it, or if we knew about it and took remedial steps. So all is not lost on this particular standard. We still have defenses. That defense is not available in New York City. New York City is a whole different frontier. One other thing that will come into play with this murky standard is retaliation claims. So a lot of times you'll see an employee run into the state division, run into court, run to the EEOC, and say, I've been the victim of a hostile environment. And that complaint, let's say, has 0 merit. The employee is subsequently fired and then says, I was fired in retaliation for my complaint. One argument we typically make is, well, your complaint doesn't constitute protected activity because no one could reasonably believe what happened to you constituted harassment. And there's some cases out there that support that proposition. I think now with this more murky standard, it is going to be a little harder to make that argument. And I am dealing with cases right now where you do have an employee running in and filing these complaints. I have 2 at the state division, and they're still there with the company, which is a very hard thing to deal with when you have a working plaintiff, so to speak. And in these cases, really what the people are alleging to be harassment is not harassment. Supervision is not harassment. Having expectations of employees, even if they're intense expectations, is not harassment. And what is happening in these cases is that the employees are not happy with their supervisors, they're not happy where they're working, they don't want to quit, they want to get themselves actually fired. And so they're trying to set the stage for a retaliation claim. And it's very hard to deal with that. Now, what has happened is that in these cases, the employees are still doing their substantive job, but they're creating a toxic atmosphere, and they are bothering other employees with the toxic atmosphere. And in some of these cases, we even get complaints from other employees saying, I can't work with this person anymore. You don't get rid of her, I'm going to have to be the one to leave. Now, in some of those cases, it gets to the point where we do terminate the employee and say, well, we're just going to have to take the risk of the retaliation claim. But it would have been nice to be able to rely on this second prong of a defense that there was no protected activity in the first instance. So the next thing is about non-employees. We're seeing more and more of this in the case law. Not too much where the non-employee is the one who is bringing the claim, but where our employee is the one complaining about being harassed by someone who is not an employee. There are some cases out there to be mindful of. One, a recent case involving Costco, where you had a patron, a customer, harassing an employee and actually eventually stalking the employee. And it got to the point where it was out of control, where the employee actually needed to get in police involvement. The court said, look, it doesn't look like, Costco did some things to protect it, but not enough. And there can be liability for that. In the education setting, seen cases where it's a student who has become obsessed with a teacher or a professor, starts stalking that person. There could be liability for that. So that goes on. And there was just a case out of Michigan that came down within the last few days in a hospital where you had a patient that was making racial epithets at a nurse. And again, that can give rise to a claim. So we have to protect our employees from all of these different situations. One thing I kind of hear a lot when I attend some of these conferences on this topic, for whatever reason, they like to use as the hypothetical the UPS guy coming to deliver stuff and harassing people. I don't know why the UPS guy has been singled out for this. I'm not aware of UPS having any kind of harassing employees. It's not part of their business model. One just quick war story about this. Did have a case where the UPS guy was involved, but not as a harasser. We had a case for a real estate mogul who was accused of sexual harassment. Hard to believe that a real estate mogul would be accused of sexual harassment. But nonetheless, the employee who brought the complaint was saying that the workplace, which is a relatively small workplace, was like a modern-day Gomorrah, with all manner of sexual exploits going on. And one example of the hostile environment she claimed is that the company had this little kitchen area like we have in our office, and she walked in one day and saw the boss having sex with another employee. And this contributed to the hostile environment. And I would have to say if that did happen, yeah, that would contribute to a hostile environment. We started interviewing all the other employees about this. We got to one employee and asked about this particular incident, and the employee said very matter-of-factly, look, the plaintiff is mistaken here. That was not the boss having sex with someone. That was me having sex with the UPS guy on the kitchen table. And she said it like, doesn't this happen all the time everywhere? So that, these things come up, and we frown upon this as employment lawyers. We don't want our workspaces to be used for this. Again, we want our employees just to come to work and do their job and not be harassing people. And we want our employees to come to work and feel safe that they will not be harassed. So at this juncture, I will turn it over to Teresa.
Thank you, Howard. As I'm sure all of you are getting the gist of, there's been a broad array of changes, and we're not done yet. So I'm going to be talking about the changes the law made to non-disclosure and confidentiality of claims. If you think back to the first round of legislation we saw for the sexual harassment law, you know that for sexual harassment, we've had the law in place for about a year now that you can't have confidentiality clauses addressing sexual harassment claims unless it's the complainant's express preference. So what this law did, similar to what it did for many other types of claims, is it expanded that confidentiality and non-disclosure provision for not just sexual harassment, but all types of harassment and discrimination on all bases of protected categories under the human rights law. So it's a broad and ban on confidentiality clauses addressing any and all discrimination claims. And these clauses can only be used if it's the complainant's preference and a specific legal process is followed. So what the law says is you can put these bans, you can put confidentiality and non-disclosure provisions in, but they need to be the complainant's express preference and to follow this legal process. To give you a sense of what that legal process is, it's things like the agreement needs to be in writing, there needs to be a 21-day period of consideration before it can be an effective agreement, and the complainant or the plaintiff needs to have 7 days to consider the agreement and have a 7-day revocation period after it's signed. Beyond that, the terms of the agreement must be written in plain English and, if applicable, the primary language of the complainant as well. And you'll see this primary language piece pop up again in just a couple of slides. But beyond that, still sticking with the confidentiality provisions, if the confidentiality provisions are included, if they are the complainant's express preference and all the waiting periods are satisfied, the confidentiality provisions still cannot limit subpoenas and subpoena-related activities, such as testifying or complying with the subpoena, cooperating or participating with an investigative agency, providing information to unemployment, Medicaid, or other public benefit claims, or disclosing factual information related to future claims, unless also advising that the party can speak with law enforcement, the EEOC, the Division of Human Rights, and other similar agencies. So these changes are going to be effective, by and large, October 11th of 2019. I very often get the question, well, if the confidentiality just applies to the facts and circumstances of the claim, can we still keep the settlement amount confidential? I think that's a bit of an open question myself. The law doesn't expressly prohibit it, but given where the law is going here, I wouldn't be surprised if that eventually becomes a facet of it. Another thing the new law does is it looks at these mandatory arbitration clauses. Similar, again, to what we first saw under sexual harassment, we now see broadened for all types of harassment and discrimination claims. So this is a ban on mandatory arbitration clauses and agreements addressing any and all discrimination claims above and beyond sexual harassment and any harassment claims as well. The thing that we have to pay attention to here is the court decision in Lateef versus Morgan Stanley, which came out on June 26, 2019. Now, the timing of this is very interesting because on June 26, 2019, this new sexual harassment law had been passed by the state legislature, but it had not yet been signed into law by the governor. It wasn't signed into law by the governor until August 12th. So in Lateef versus Morgan Stanley, the court looked at the mandatory arbitration law for sexual harassment agreements and struck it down, said it was preempted by federal law under the federal arbitration provisions, and that the law could not stand. The court also noted in a footnote in that decision that this proposed law that was not yet signed by the governor would not do anything to alter their decision there. So, I mean, I think that's a pretty good indication that broad bans on mandatory arbitration agreements, this part of the law is going to be found unlawful by a court. But since we don't have that explicitly right now, we just have to rely on it for the sexual harassment piece that was already passed and struck down.
And I think there was a footnote in that, if I'm not mistaken, right? There was the legislation had passed, right?
Yes.
Yeah.
Andy, you're right. There was a footnote in there that said the legislation's passed, it hasn't been signed, but we would not consider that legislation to preempt the federal arbitration provisions in general. So beyond that, the new law also sets forth mandatory sexual harassment training and policy language. Specifically on the policy side, the training side is things we've already been seeing. I know everybody listening is well aware that they have a mandatory training deadline of October 9th of this year, so that just codifies that provision in a different way into the new law. But beyond that, it says policies must be provided at the time of hiring and at every annual training program. So that means not only do you have to train your employees annually for sexual harassment, you have to actually distribute the policy at that time as well, and certainly the policy needs to be distributed at the time of hire. I think most people listening have just included that policy in their employee handbook and are just distributing the entire thing at the time of hire. Beyond that, policy and the information presented at the sexual harassment training must be provided in English or in the other primary language of the employees as specified by the state. New York State has released the training and the policy in a number of languages, It certainly has not released them in all languages that are spoken in New York State. So one of the things that the law has said is if the state has not released the training in the language of the employee, then you can default to the English language. I frankly think that's a rather big risk to take if your employee does not understand the sexual harassment training because they do not understand the language. It's still going to be the employer's responsibility if that employee is harassed and makes a complaint. So what I've been doing for my clients who have employees that don't speak English or don't speak English primarily, but the state still hasn't released the training, is we've been hiring translators and interpreters to actually do that work for us. So those changes are effective immediately. They'll apply to any policies, release, and trainings you do from here on out. There are also other significant new changes to the law. There's a lot on this slide, so I'm just going to talk it through one by one. The first one is that employers of all sizes are now covered under the human rights law. That's probably not going to affect most people listening. The previous law was that anyone with 4 employees or more was covered. Now it's anyone with any number of employees, even less than 4, are going to be covered under the human rights law. The human rights law was also specifically expanded to include political subdivisions and government entities with this most recent round of regulations and law. Beyond that, the new law mandates the award of attorney's fees to a successful party. Really what that means is a successful claimant. So now I think what we're going to see is a lot more plaintiff-side attorneys becoming involved in these administrative proceedings, particularly these Division of Human Rights proceedings, because if they're successful, they are able to collect attorney's fees for that claim. So that certainly is going to involve a lot more plaintiffs' attorneys jumping into the ring because now their fees are allotted for under the law. So that really just applies to plaintiff side. If you're a successful defendant, the only way you can get attorney's fees is by making a special motion that shows that the underlying claim was frivolous. I'm not going to go into the particulars of that right now. Just know that it's a very high bar. Claimants will have 3 years to file with the Division of Human Rights instead of the 1 year they have now. So the important thing to note about that is while almost everything we've talked about this morning has applied to all types of discrimination and harassment, this 3 years only applies to sexual harassment claims. So what that means is now, instead of having 1 year to file a complaint with the Division of Human Rights, you're going to have 3 years to file sexual harassment-based claims with the Division of Human Rights, which, again, much like the new standard that we have that strikes severe and pervasive, really takes the world of claims that we can have and makes it a lot bigger. So look out for that coming in the near future. Finally, punitive damages, while not able to be awarded against state or local departments, agencies, or boards of commission, can now be awarded to private employers apply against private employers, I should say, under the human rights law. So that's something I think we're going to see, along with the attorney's fees, really make the potential value of these claims much, much higher. And so that affects a lot of decisions that employers must make, whether that's settling or going to court or how they enforce and deal with these types of claims in the future, because essentially our world of damages just got quite a bit greater. So that brings us to a couple of practical recommendations. I think most of these practical recommendations can be summed up into something that I've been saying ever since I knew this new law was a possibility, which is that you really cannot be too careful out there when you're dealing with harassment and discrimination in the workplace. That extends to things like revising your mandatory sexual harassment training and your policy as needed. If any of you have the severe and pervasive language in there, that needs to come out. That's no longer the law for New York. Also, if you have in there that complainants have 1 year to file with the Division of Human Rights, that needs to come out. That's no longer the law in New York for sexual harassment. Although, as I mentioned, that is retained for other types of discrimination and harassment. You'll want to obtain translations of sexual harassment training and policy materials as necessary. As I said, the state has released some of those For those of you who have employees who are not included in the list of languages that the state has released, consider hiring translators and interpreters to get those materials in place for you. On the arbitration and confidentiality side, you'll want to review existing personnel agreements to address the confidentiality and arbitration issues, including such agreements as employment, severance, and non-compete. All those types of things are fodder for where we traditionally see confidentiality and non-disclosure, and we just need to be mindful that that may no longer be the law in New York State. And with arbitration issues, kind of stay tuned, although I do think they could easily be preempted by federal law. Beyond that, educate your leadership about significant changes, especially the new lower threshold for harassment claims. That gets back to what I said about you can't be too careful. Leaders in your companies need to know what exactly the new standard is for harassment so that they can better respond to employee complaints, so that they can make better recommendations about what needs to be investigated and what needs to go to human resources. Along those same lines, you want to create or review investigatory procedures and plans. It's now more important than ever that you promptly address complaints. You need to have that process in place in terms of who will be investigated, who's going to do the investigating, who else is going to be involved, if you're going to involve a consultant or counsel, what else will be done in terms of interim measures for the parties. Are you going to put people on paid suspension? Are you going to allow people to transfer to different work activities pending the outcome of the investigation? And then how quickly the investigation will need to be done, how quickly that outcome will need to be communicated to other individuals, all types of things like that. The time to address what your investigatory procedure is going to be is right now. It's not after you get your first or second or third complaint. It's to have that procedure in place before it even becomes an issue. You'll want to use trainings to raise the emotional IQ and enhance the empathy of staff and especially supervisors. It's certainly the case in most workplaces that employees take the tone of the workplace from the supervisors in it. So you want to make sure those supervisors are aware of the type of behavior that's considered appropriate and inappropriate in the workplace and that they model that behavior. Carefully documenting all employee complaints, remembering that the standard is now just something more than trivial or petty. As Howard had said, the world of what was once considered harassment and discrimination above and beyond sexual harassment has now just expanded in a very significant way. There's a lot of room between severe and pervasive and trivial and petty, and that room is where we're now going to start seeing different types of claims come into play. Please keep spreading the word. It's very important to be respectful 100% of the time. Those of you that know me know that I'm a big fan of the so-called platinum rule, which is to treat other people the way that they want to be treated. I'm going to turn it back to Andy now to discuss sexual harassment training and wrap us up.
Thanks, Teresa. So just to go back a second, too, and I think emphasize some of these practical recommendations, and Howard, feel free to chime in, too. With respect to the new language requirement, this is something that the state had put out guidance under the, what I'm going to call the old new rule, before encouraging employers to provide it in the employee's primary language other than English. Just as a practical matter, we think that's a good advice because you want to make sure they understand and can comprehend the information. But it wasn't actually part of the law. So they've made this change to now codify this requirement. And again, the state does have information on their website with these policies and training in other languages. We can provide a link to that if you'd like. I think the other issue, Teresa, will be where, because there were features of the model policies, I think that were problematic in a number of respects. Many employers took the approach of providing their own and customizing their own policy and training program that still met the minimum requirements for what the state said needed to be in there, but that will differ from those model policies that are available through the state. In that case, you will want to obtain a translation to the extent you need to for your customized policies too. I think with the item 3 in terms of the confidentiality agreements or provisions in contracts, employment contracts or settlement agreements especially, If you're using a stock, we see this from time to time with clients, they have a quote-unquote stock settlement agreement or severance agreement that they use. These should be reviewed and modified with legal counsel. There's ways that we're able to deal with this issue of the complainant's preference. It has to be the complainant's preference to include such provisions in there. In my experience, when I'm resolving cases, and those cases involve payment of some type of monetary compensation. In other terms, certainly it's the desire to keep those confidential, and it's also often the plaintiff's or the complainant's preference to keep them confidential. But to avoid this becoming some type of bargaining chit in the course of a negotiation, I think it's important to take certain approaches and strategies, and again, we've had success in that regard to date. I think
just a couple of
IQ. Oh, sorry, Howard, go ahead.
Yeah, just a couple of just quick thoughts on this. One, just going back to statute of limitations, if public entities, particularly public schools, may have a shorter limitations period, so they ought to check that. One thing I think is important to do when someone does come forward and make a complaint, that during the investigation and even after the investigation, that someone kind of just check in with the complainant and make sure everything was okay, make sure there's no further incidents, make sure there's no retaliation. You know, I would do that in person and also confirm some of those conversations in emails, you know, just checking in. Because a couple of things could happen. Harassment could be continuing and the person doesn't feel comfortable coming forward, or there could be threats by the harasser, and we want to know about that, and we want to have a record that we're double checking. One other thing in terms of investigations, again, it's important that we have an environment that doesn't tolerate harassment, but on the flip side, we have seen some institutions get themselves into trouble by making rash decisions, particularly when the media is involved and there's an outcry for the company or the institution to do something right away, immediately. We saw that with the Duke lacrosse scandal, where people reached their conclusions right away. Even professors putting full-page ad, basically convicting people before there was any kind of process. I've had in my own experience doing investigations where things initially seemed like there wasn't harassment, but then upon further digging, you find out there was. And on the flip side, we've had situations where even something that looked like a smoking gun at the beginning of it, that there was harassment, turned out not to be. And just a very quick example of that, we had a case where a complainant came in with a horribly harassing email from a supervisor, and there it is. You know, it's there's no better evidence than that it's in writing. It's plainly and clearly came from the supervisor's computer, and should be case closed. But upon further digging, it turned out the company had a system where you had to swipe in and out when you came in and when you left, and the email was actually sent after the supervisor had left for the day, but before the employee had left for the day. And so what happened? It turned out that he left his computer on, and she hopped on his computer. She was mad. She had gotten a bad evaluation and sent the harassing email from his work computer to her work computer. That's a scary thing, because you think about somebody's life is at stake there, not in a life or death, but it professionally could affect his home life and all that. So I think with these investigations, I would not trade thoroughness for speed. I would just be careful about that. And then one other thing is just in terms of emotional IQ. We have had situations where we have a supervisor who's just absolutely, in terms of job performance, terrific, but not great people skills. And that could lead to an employee feeling that, well, maybe this person doesn't like me because of my characteristics, whatever that may be. And it's a horrible defense to have to make in court, and we've sometimes had to do it, where we'd have to say, no, this person wasn't mean to the plaintiff because of her gender or because of his religion or whatever, or age. He's just mean to everybody. Again, we don't want to make that defense. So I've had seen companies have tremendous success using job coaches to work with certain high-level employees who just have bad people skills. So thank you.
Thanks, Howard. All right, so one thing we did want to mention here from our team, we know that many of you are working on your training. If you haven't implemented it on a company-wide or organizational-wide basis, I'm sure will be planning to do so soon with the October 9th deadline in place. That still applies. The firm has crafted an online training portal that is interactive in nature, that meets the state and New York City requirements. We have taken into account these changes in terms of the differing standard for harassment and reflected that in our training. If you haven't checked it out, I encourage you to do so. You can access a demo through our website at bsk.com. It's a half-hour program, and again, it's designed to be very cost-effective, very practical, and if you have your own learning management system, we can incorporate that and load it into your system, or we can use it on our own learning management system too. So feel free to contact us if you have any questions about that. So we did receive a fair number of questions here. We have a little bit of time left. I don't know that we'll be able to answer all of them, but again, we'll follow up with you and address those questions if we don't get to them right here and now. One of the questions that we did receive that I'll throw open to Howard and Teresa is, well, what if my headquarters is not in New York, but I have employees who work in New York? Do I have to provide them with training and policy?
I can take that one. Yes, you do. If you have employees that are working in New York in any capacity, regardless of where your headquarters are located, they need to be trained in the New York law.
Okay. Howard, maybe this one would be for you. We did receive a question about what constitutes comparator evidence. So what is that type of evidence that, at least to date, complainants have had to provide?
Yeah, so again, let's say I'm the complainant and I say I'm being treated in a discriminatory manner because of my age. So the comparator evidence would be I need to point to someone who is under 40 who is receiving favorable treatment to me. So let's say I'm up for a promotion and I've been working for the company for 10 years. I have the highest level of evaluations, and I get passed over for a 25-year-old who's done virtually nothing, and that would be my comparator. That it can't just be that I'm saying the sole basis for my claim is that I'm over 40. The fact that I'm over 40 doesn't mean anything. It means that I'm protected, but in order to have a discrimination claim, I need to show that I was treated differently from someone else. Now I don't need to prove that, at least. But again, I still think you're going to have to come up with some evidence of some reason. Again, let's say that maybe a supervisor said something to me, like, we just don't want to have an older crowd being in supervisory positions. We're looking for a new young workforce that's vibrant and whatever. Now, I would need some sort of evidence like that.
Thanks, Howard. So another question we received is, I think, a good one. Why all these different effective dates?
Well, that is a question that we have as well, whoever asked that, because New York said so. They could have made the entire thing effective immediately. I'm not quite sure why they did it. I can guess that perhaps they wanted to give different effective dates to allow people at the Department of Labor and the Division of Human Rights a little bit of time to release new materials and get caught up with this new law. But simply put, we don't know. They just decided to put those dates in there for us.
All right. So another question we received is, in terms of updating my policy and training, when do I need to do that? And if I haven't done my training prior to the October 9th deadline, should I change things now? And I'll open it up to the group here. I would just note that I think the training deadline is October 9th. I think the effective date for the changes in the standard is October 11th.
Yeah.
Right? So technically 2 days later.
As a practical matter, I would change your materials right now. There's no reason not to. It's the law coming up. If you haven't done your training, do your training to the new standard. If you haven't released your policy, or if you're re-releasing your policy, just change it to be the law, as it's going to be very shortly.
And in terms of the new requirement for providing it at the time of hire, what if it's a situation where the employer is doing its usual onboarding process, right? Is that an appropriate time to give them the policy?
Absolutely. I always encourage the training and the policy to be given at the time of onboarding. It can go along with the rest of the procedures and policies being introduced by the employer.
Great. Howard, maybe for you, so when we've done this training in the past, we harassment training in general, we talk about that the conduct has to be both offensive on an objective basis and also subjectively offensive. And is that standard changing here? It doesn't have to be reasonably offensive, or is it just that what's offensive is now the bar's lower?
I haven't seen it fleshed out in those terms, but I think we're really looking at an objective standard of whether it rises above that level or not. I don't think we're dealing with strictly someone's own sensibilities. It looks like they're looking at an objective test. And
Okay.
again, I would emphasize again that the sole issue isn't whether they meet the standard. It's really how the employer responds to the complaint.
Thanks. Another question we've got, and I know I've received it before, is, well, we have volunteers. Do we have to train our volunteers? Do we have to provide our volunteers with a copy of our harassment policy? And there, the statute, when it talks about non-employees, it talks about contractors, subcontractors, and consultants who are working in the workplace pursuant to some agreement, or they're an employee of such an entity. And it doesn't expressly cover volunteers, but the human rights law does cover interns. And I think in some ways interns share many qualities of volunteers. And so while the statute does not squarely address this, I think it can be a good practice to have your volunteers trained, to have them receive a copy of the policy, and to understand your expectations in terms of their interactions and dynamics with others in the workplace. It doesn't necessarily have to be the exact same training that you give to somebody else, one of your rank and file employees, for example, or as extensive, but I think incorporating some form of training, even if not necessarily required under the law, is advisable. And have a great day, and please everyone enjoy the holiday Labor Day weekend.